Hello, my name is Michael Tessaro and I prepared this presentation entitled Demystifying Competition and Consumer Law Penalties. And the reason I've prepared this presentation is because the ACCC has recently released some guidelines on how they calculate penalties. And I think it might be worthwhile to go through the guidelines and look how they approach the issue and some new guidance I think they've provided which hasn't previously been disclosed to the market. So I'll go through that in this presentation. Now, a bit of background about myself. I'm a competition and consumer lawyer, and I've been running my own practice to Tessaro Legal Consulting for the last 15 years, and I help companies, individuals with competition and consumer law matters. Prior to that, I worked at the ACCC 15 years in a variety of roles, including as a Director of Enforcement. Now, the outline of the presentation, I'll start with a bit of an introduction, then look at the guidelines on ACCC approach to penalties in competition and consumer law matters, which was released in September 2023. It wasn't really publicised very much, and so I think it's worthwhile for practitioners and businesses to be aware of what it says. Then I'll look at this High Court case, the King and Jacobs Australia, which is very significant in the interpretation of the penalty provisions under both the Australian Consumer Law and the Competition and Consumer Act. Then I'll use a little bit of a case study, ACCC and Superphone, which is a case that I was involved in, just to look at one of the issues that I think the guidelines don't really deal with and probably should have, and then finish with some commentary. Now, just by way of introduction, there are probably three main principles that apply in the assessment of civil pecuniary penalties and probably more broadly just in sentencing. The first is this idea of instinctive synthesis, and it's an interesting concept. There was a bit of debate in various cases whether there should be maybe a more mathematical two-step approach to working out sentences, or whether it should be more of a process of instinctive synthesis. And the issue was probably put to bed, so to speak, in the case of Markarian and the Queen, or versus the Queen in 2005, where the High Court determined that the instinctive synthesis approach is the right one to take. So it's a movement away from using mathematical approaches to calculating both sentences and civil pecuniary penalties. And there is probably a description of what it involves. This is from accused judgment. It's a method of sentencing by which the judge identifies all the factors that are relevant to the sentence, discusses their significance, and then makes a value judgment as to what is the appropriate sentence given all the factors of the case. So really it's putting all the factors together, weighing them all up, and arriving at a number. So clearly it goes against any idea of a mathematical formula. And it's been criticised as being maybe too based on the instincts of the judge as opposed to a true synthesis of the relevant factors. But anyway, that's the approach that courts take to the imposition of civil pecuniary penalties. The second issue that's relevant is also from Markarian, and this is the idea of what's the relevance of the maximum penalty. And the High Court, this is from the majority decision, said it follows a careful attention to maximum penalties will almost always be required. And there are three reasons. Firstly, the legislature has said that that is the maximum penalty, so you can't really ignore what the legislature said. Secondly, it invites a comparison between the worst possible case and the case before the court at the time. And then thirdly, because in that regard they do not provide, taken and balance with all the other relevant factors, a yardstick. So effectively the maximum penalty provides a yardstick for the penalty in the current case. So it seems to me that, that maximum penalties have to be calculated by the judge in a penalty decision, and then some regard has to be taken to that maximum penalty. And it's also said in this particular case that there has to be some theoretical relationship between the penalty imposed and the theoretical maximum. And then the final issue with deterrence, and this was another High Court case, ABCC and Patterson, which was in 2022. And what it was looking at was a decision by the Full Federal Court where they had applied an approach which looked at the sort of worst possible case and then compared the current case with that worst possible case. And what the High Court said in Patterson was that was the wrong approach to take. The proper approach to take, and I'll just read it out, under the civil penalty regime provided for under that Act, but realistically under all federal acts that impose civil pecuniary penalties and probably state acts as well. The purpose of a civil pecuniary penalty is primarily, if not solely, the promotion of the public interest in compliance with the provisions of the Act by the deterrence of further contraventions of the Act. So in imposing penalties, you have to consider what penalty is required to achieve deterrence of this particular person or organisation, and to achieve general deterrence in the industry. So that's what you've got to be looking at, not this hypothetical worst possible case. And in some respects, you probably think it's a little bit inconsistent with what Makarian said, but it's quite clearly the case that deterrence is the pretty well the sole factor you've got to look at when imposing a civil pecuniary penalty. Now, looking at the guidelines, they start off with the purpose, and obviously they're focusing on the principal matters which the ACCC will take into account in preparing penalty submissions that are proposed to the court. So ultimately, the court has to determine what the penalty is, and as they make clear there, based on the Pattinson decision, it's all about what will be required to achieve deterrence. And the ACCC never really spelled this out in any guidelines before, so that's why it's an important document. First time the ACCC sought to explain its approach to, putting together penalty submissions, talking to respondents about the penalty they think are appropriate in a particular case. Also, to promote consistency in the way the ACCC approaches penalty submissions. And I think it's fairly notorious that there's really very little consistency in the penalties which are imposed for breaches of the Australian Consumer Law and the Competition and Consumer Act. So anything that promotes consistency is to be welcomed. And finally, to increase transparency in the ACCC's approach. And they say the broader community, okay, they probably want to know how the ACCC works out penalties, but probably more importantly, businesses and practitioners need to know how ACCC is approaching these issues. Now, they set out 5 steps, and I'll go through them quickly, but then I'll go through each step individually. So first one is to identify the contraventions. How many contraventions are there? Is there a course of conduct? Secondly, identify the numerical guides, and that's obviously the maximum penalty. If there's 10% of turnover required, there's 3 times the benefit arising from a contravention. So you work out all those factors, as well as how much loss was caused from the contravening conduct and how big the contravener is. So annual turnover, profits, things like that. Step 3, you consider the factors relevant to penalty, and there's 2 sets of factors. Firstly, the ones set out in the legislation, but also secondly, a number of factors which have come through in various cases. So the French factors and some other factors by Heary and another decision. So they all get looked at as relevant. Obviously, the statutory ones have to be considered. The other ones are often considered, but they're not like a statutory checklist. And they involve things like deliberateness, how senior the people were who engaged in the breach, whether there'd been previous illegal conduct by the firm, and their culture of compliance. Fourthly, you look at whether there should be any reduction in the penalty, and as you can see, it says cooperation, so that's only one factor you get any reduction in penalty for. What's notably not there is the financial situation of the respondent. That's not a relevant consideration under step 4. And then step 5, any fine adjustments, and this idea of totality, which is also a concept from the criminal law, co-contraveners, so relativity between those, and comparable cases. So looking at step 1, obviously the key issue in step 1 is whether there's a course of conduct. So effectively what the ACCC has said is that there won't be a course of conduct if these sort of factors exist. So if they're separate, unrelated or discrete acts, if they're temporally distinct or the different parties involved, different circumstances or different decisions has led to the contraventions, and they're different outcomes in terms of revenue, profit, savings, benefits, loss, damage. So if these factors exist, it's unlikely to be a course of conduct. So I think the classic example of a course of conduct might be an advertising campaign in print form, radio and television. And the same representation is made through all those 3 media, but on the print media it occurs 10,000 times, and radio it occurs 100 times, and in television it occurs 50 times. So often the court will say, well, you've advertised, you made the representation in 3 different media, so we'll say there's 3 separate courses of conduct. So there might be, that means there are 3 courses of conduct which will be liable to a penalty, rather than adding up 1,000 print ads, 100 radio ads, and 50 TV ads, and saying, okay, it's 1,150 times a penalty. So that's what the course of conduct. You look at similar types of conduct and you group them together. Often if, representations have been made in different media, that's the most common way that you arrive at a course of conduct. Now you go to number 2, and this is where you actually look at the numerical guides. Obviously, you're looking at, the financial gains and benefits, but it's important here to note it's not actually the benefits made, it's what's expected to be made. So if you're trying to set up a price fix that's going to make you a lot of money, you'll be penalised accordingly. And I think the best example of that is the recent BlueScope case, where there was a long-term attempt to engage in a price fix in flat steel, and it failed, and the penalty imposed was over 57 million. And even though they had no benefits, the penalty was linked to their expected benefits, which were going to be huge if it had been successful. So that's important to be aware that expected benefits will be calculated. We sought to be calculated in order to work out penalty. Financial harm or loss to others, that has to be, I guess, actual loss or harm, and the scale and resources of the contravener. So how big are the parties involved? Now, this is an interesting observation by the ACCC, and this is sort of responding, I think, to the Pattinson High Court case. And it says the statutory maximum is not reserved for the most serious examples of misconduct, and there may be circumstances in which, although it may be possible to imagine the worst case, the ACCC considers a penalty close to or at the maximum is otherwise required for deterrence, and it will seek such a penalty. So what it's saying, that the whole approach of working out the worst case scenario, long-term contravention spanning many years that results in lots of harm by a repeat offender against vulnerable consumers buying life-saving drugs, the worst possible case scenario, that's not the right approach. The High Court in Patton said, no, that's not correct. Really, it's looking at the ability of the fine to achieve both specific and general deterrence. That has to be the only guide. And they also make this other point, which is relevant. Sometimes you might have separate contraventions, and if you did the mathematics and you multiplied it by the relevant penalty, you'd arrive at a theoretical maximum penalty which was so great that it so far exceeded the amount necessary for deterrence that it's effectively meaningless. And in that case, you can ignore this theoretical maximum and take a different approach. And this is the Reckitt Benckiser case that principle was established. So I guess the other numerical factors, obviously, which are looked at is, the 10% of turnover and 3 times of the benefit that has been derived from the conduct, which I'll come back to a bit later. Then you go to step 3, and this is considering various other factors, and these are well understood. Systematic conduct, high level of coordination, if the person or the company before you was the instigator of the wrongdoing, the length of period over which the contravention occurred, if it affected a lot of consumers, including small business consumers, if it was directed towards vulnerable consumers, so for example, aged people or indigenous people in remote communities, whether it involves a product or service that is of importance or in high demand, so assuming if it's a life-saving drug, as I mentioned before, that's going to be an aggravating factor. It involves product safety risks or concerns. So obviously anything that results in people's lives being put at risk is going to be an aggravating factor. Affects a market that has considerable economic importance to Australia, so the bigger the market, or if it's a growing market and somebody's trying to stop innovation, that's going to be an aggravating factor. And if it involves retaliation or coercive action against others. So these are all aggravating factors that are going to push the penalty upwards. Then there's further considerations as to whether the conduct has the effect or potential effect of achieving broader anti-competitive outcomes. So limiting or distorting competition or consumer choice, increasing prices or reducing quality of goods in the market, or providing contravening business with an unfair advantage over its competitors. So this is all about interfering with the competitive process or competition between companies in a market. So all these factors will be aggravating factors. So this is quite interesting because this is not something that's been very prominent in ACCC submissions in the past, and I think they'll be pretty prominent in ACCC penalty submissions going forward. So they also had this large section looking at non-financial issues. So I think the penalty submission department very focused on financial issues, but here the agency is making it very clear that they're going to put a lot of emphasis on the non-financial detriments arising from anti-competitive conduct or misleading conduct. So you can see there non-financial or unquantifiable loss suffered by competitors, loss of opportunity, forced to exit the market. Again, you've got the distortion of consumer choice, distortion of prices. Then you've got reduction in the quality of goods, suppressing innovation, loss of opportunities for those affected by conduct to obtain goods or services on more beneficial terms and conditions, loss of opportunity to those affected by the conduct to exercise rights based on accurate information. So that sounds very much like consumer guarantees, if people are prevented from exercising those consumer guarantee rights. And another very interesting one, unquantifiable loss suffered by those who are affected by the contravening conduct or non-financial harm caused by the conduct. And then the examples, anxiety, distress, risk to physical safety and well-being. So these are factors that you don't often see in ACCC submissions, but I think we can fairly assume that this is going to be a prominent part of ACCC submissions going forward. You know, vulnerable consumers and the distress and anxiety that contravening conduct has had on them is going to be an aggravating factor. So you also have the more, I guess, more traditional factors. So deliberate contravention is an aggravating factor. How senior the representatives of the business are who are involved in the contravention is also going to be an aggravating factor. And clearly similar conduct. So if you're a repeat offender, the penalty invariably has to go up because deterrence hasn't worked in the past. And then the corporate culture conducive to compliance, it sort of cuts two ways. Obviously, if you have no culture of compliance, then that's an aggravating factor. But if you do have a culture of compliance and for some reason your compliance programs have missed a contravention, then this can actually help you probably mitigate the penalty. So that goes both ways. Then you get to step 4 and you're considering whether there's any reduction to the penalty that's been determined in the first 3 steps due to cooperation. And here the interesting thing is ACCC has actually put some numbers to the level of discount that you could get for cooperation. It's quite high actually, 30 to 50% if you cooperate. And I guess in the criminal setting, I think it goes up to about 40%. So it's higher potentially for respondents in competition and consumer law cases. They could have a reduction in the penalty of 50%. But when you look at what cooperation involves, it's not easy to, I guess, achieve the 50%. You've got to do a lot to get 50%. It says full and meaningful cooperation means cooperation during the investigation, admissions as to a liability, provision of admissible evidence, agreement as to the penalty amount to be submitted, and providing significant assistance in relation to other proceedings and contraveners. So you've got to cooperate during the investigation, admit you did it, agree on probably a very large penalty, and then help the ACCC go after anybody else engaged in the contravention. So it seems that if there's a contravention involving 2 companies, the first one has a potential to get 50%, the second doesn't, because obviously they can't provide assistance in relation to the proceedings to get the other person. So this is really helpful because I don't think there's ever really been a guide as to the approach the ACCC is going to take. There clearly hasn't been any numbers. I've seen cases where they've talked about 25% or 20% reduction, but this is suggesting for full cooperation, you're going to get at least 30% 30% reduction in the penalty. So that's significant. Then step number five, is sort of the catch-all provision where you just have a final look at various factors. So the first is totality, which, as I said earlier, is a criminal law concept, which is where you have a final look at the penalty derived after going through the instinctive synthesis, and you just see whether it is feels right, whether it's appropriate. So it's I guess the last minute gut feel as to whether the penalty looks right. So as you can see, there are separate penalties being sought for multiple contravention. The cumulative total of those penalties will be examined to consider whether it's appropriate and if it needs to be adjusted. And then there's co-contraveners. So it's important, if there's multiple contraveners and other people have been fined, that there is some relativity between the fines imposed. So as you can see, where there are multiple contraveners, the ACCC will consider whether the penalty sought for each should be similar. So that's really important. There shouldn't be vast differences between penalties for people engaged in the same conduct. However, then they say about comparable cases. This is where I think it gets a bit funny, and this is true. The ACCC rarely accepts that any case that's put to it is comparable. And as you can see here, they say it's usually a limited relevance. It may refer to previously decided cases, but really previously decided cases aren't very much help for four reasons. Firstly, there are almost always relevant and significant differences. Where cases are truly comparable, the fact of further equivalent contraventions is likely to suggest that the earning penalties were not high enough. So that sort of, somebody breaches a law, gets fined to achieve specific and general deterrence, and then you say, well, we should be fined the same amount. Well, the ACCC is going to say, no, you should be fined more because the previous penalties didn't work. Like, whose fault's that? It's hardly the respondent's fault. But anyway, so that's another reason why comparable cases won't be looked at. Changes in the value of money over time. So inflationary factors will be taken in consideration. And finally, changes to the maximum penalty will require larger penalties. So clearly the penalties under both the Australian Consumer Law and the Competition Consumer Act have gone up dramatically. So they're going to be much bigger fines. But I think the problem with this whole assessment is that the purpose is to achieve general deterrence. And so you're saying to people, if you engage in this conduct, you can expect this sort of penalty. But then the ACCC say that these penalties are irrelevant to the penalties that can be imposed against you. So it seems to be a contradiction there between the concept of general deterrence and the importance of comparable cases. And I've seen some situations where almost identical cases which were put forward to the ACCC have been dismissed on pretty weak grounds, and a much bigger penalty has been imposed. So this is disappointing. I think there really needs to be some more weight given to comparable cases. I think in other areas such as the criminal law, comparability of cases is a really important part of the judicial process. And the final thing that they consider is other forms of relief. And I think this is an important observation, that clearly when you're looking at the penalty, you can't ignore the fact that a company may have provided redress, compensation to various people. This is all has to be very relevant to the penalty imposed. Clearly, if somebody has no intention of providing redress, that should be an aggravating factor. It should be mitigating if they've actually taken some steps. And also on individual penalties, some of the remedies sought should be relevant to penalty. For example, if say you've got a disqualification order against a director for 5 years, that should mitigate the penalty imposed. To impose a very big penalty and a 5-year disqualification seems somewhat unfair. So there has to be some consideration as to the relativity between those two remedies. So there's this very nice table in the ACCC guidelines which spells out just what I've explained. So maybe you just skip the presentation and go straight to that. Now, the important case that came out earlier this year is the King and Jacob versus Jacobs Group Australia Proprietary Limited, and Jacobs Group is probably better known as Sinclair Knight Mertz. And what this involved was the prosecution under the Criminal Code for the payment of bribes to foreign officials in relation to construction contracts, and there were 3 counts of conspiracy to bribe a foreign official. And the issue that went to the High Court was what's the way to calculate the way to interpret the legislation which refers to a benefit being obtained by in this case, a defendant, but by a respondent in a civil pecuniary penalty case. And what had happened in the lower courts was that the courts had taken what they described as a net benefit approach. So effectively what occurred was they looked at the value of the benefit received for performing the obligations under the contracts, so the construction contracts, less all the costs that were paid by Sinclair Knight Mertz to third parties to enable the performance of the contract, with a little bit of a carve out to anything that was directly related to the bribery offence. So obviously costs paid to businesses to help in the construction were reduced from the benefit received, but the bribes themselves weren't able to be subtracted from the net benefit. So that was the approach which all the courts at the lower level took, and the question for the High Court whether that was the right approach or whether it should be the total gross amount that the respondent derived. And the High Court decided that the gross benefit approach was the correct approach. So as you can see in the proper construction of that particular provision of the Criminal Code, but by inference any other provision that uses similar terminology, it required the value of the benefit obtained to be determined as the sum of the amounts in fact received under the contracts secured by the bribery offence. No offence should be properly made for any cost incurred in performance of the contract. So the maximum penalty was actually 3 times the amount received. So the maximum penalty to be imposed below was 11 million, which was the 10% of turnover. But now, because the benefit derived from the conduct was 10 million, it was 3 times the benefit, so 3 times 10 million. So the penalty actually rose from about 11 million to 30 million, so a very, very big increase. Now, the interesting thing here is that that this has implications for other legislation which uses the term benefit, and I probably give a call out there to the article that I read by Michael Corrigan, Accounting in Wonderland, the High Court throws open the potential for higher competition and consumer penalties. Because I must admit I was totally unaware of this case until I read Michael's article, and that just alerted me to what he observes is that the reasoning in this particular case should apply to the penalty provisions in the Competition and Consumer Act and the Australian Consumer Law. So I think it's been fairly understood in the Competition and Consumer Act, particularly that you're sort of taking pretty much a net benefit approach. People talk about the profit derived from a marketing campaign. So you might make $20 million of turnover from a marketing campaign, but your profit might be 10%. So, you know, it's 3 times the benefit, 3 times the 2 million of profit. But on the basis of Jacobs, it'd be the marketing campaign generates $20 million worth of sales. That's the benefit. You don't actually reduce the costs. You don't look at the profits. Rather, you look at the net benefit, the gross benefit, I should say, and you multiply that by 3. So this is going to have very significant implications for the maximum penalties, as Michael Corrigan points out in his article. And if the penalties weren't high enough already, they're likely to go up much higher. And also it removes a lot of the complexity. Sometimes working out a profit margin on a transaction isn't super easy, but working out the total benefit from a marketing campaign or from a price fixing agreement is going to be a lot easier. So we may actually see the 3 times the benefit criteria in both the Competition and Consumer Act and the Australian Consumer Law being used much more regularly. And just one case I just wanted to draw attention to. This case that I did, would you believe, pro bono in the federal court. The company didn't have much money, and it's a small company, small telco. It had an annual turnover of $1 million, but it wasn't very profitable. Profit of about $5,000, and it had generated benefits from illegal conduct, which is effectively unsolicited sales of about $40,000. So that's all the people that it contacted in breach of unsolicited marketing laws and was required to pay a refund. So the ACCC went to court. We admitted liability, and we went to court really just to try and get the penalty down so the company could survive. ACCC was after a pecuniary penalty of $400,000 plus 40,000 redress. So it was after 44% of turnover effectively against a company that wasn't very profitable. We made submissions to the court that the penalty was too large and it was likely to force the company liquidation. So this is an issue that isn't discussed in the guidelines. What is the ACCC's approach to companies that are likely to be forced into liquidation by a large penalty? And I think that's an omission from the guidelines and really should have been addressed. Now, the second issue that arises from this case, which I think isn't covered in the guidelines, relates to the provisions in 227 of the Australian Consumer Law, which effectively says that the court must give preference to an order for compensation where it says defendant, but the respondent does not have the financial resources to pay both the pecuniary penalty and the compensation. So what does that mean? And we actually submitted to the court before Justice Murphy that we would pay the compensation to the consumers, $40,000, and we would do that as an initial payment to make sure the consumers got a refund, and that we come back to court later on and postpone the penalty hearing and at that stage determine what penalty should be imposed, because we didn't have the financial resources to pay a $400,000 penalty and $40,000 of redress. And we pointed to 227. We said, well, the court seems to have is required to favour or is required to preference compensation over a pecuniary penalty. Unfortunately, both the ACCC oppose our submission, say no, that's not the right way of doing it. Both penalty and redress have to be worked out at the same time, and the court accepted those submissions, which is very unfortunate, because once the company was hit with a $400,000 penalty and a $40,000 redress order, the judge decided on a $300,000 penalty, but once the company was hit with $300,000 penalty and $40,000 worth of redress, which is 34% of its turnover, it couldn't continue and it went into liquidation. And unfortunately, as a consequence of going into liquidation, nobody got any money. The Commonwealth didn't get $300,000 and the consumers didn't get a red nickel. So I think this is an issue that the ACCC hasn't dealt with. There's provisions in the Australian Consumer Law and the Competition Consumer Act that says that preference should be given to compensation where the company can't afford to pay penalties and compensation, and that needs to be addressed, I think, in any ACCC guidelines. So just a final commentary. I think it's a very useful document. The ACCC has never issued a document like this before, as far as I'm aware, and it provides a lot of really good guidance as to the way they're going to approach things. It sort of sets down some of the stuff that we already knew as practitioners, but sets out some new stuff that I think wasn't really explicit before, like the non-financial losses that the ACCC will consider. Anguish and distress will be an aggravating factor, and also the levels of discount for a penalty for cooperation, 30 to 50%. So as you see, non-financial harm, the big cooperation discounts, that's all new as far as I can see. The Jacobs case is a significant development. It's going to, I think, result in two things: bigger penalties, if that was possible, and probably more utilisation of the 3 times the benefit rule. It's just going to be so much easier to calculate the benefit because you're not netting it out for various costs. As I said earlier, they really should have looked at the implications of Section 227 and the comparable section of 79B in the Competition Consumer Act, which state that the court is to give preference to compensation above a pecuniary penalty where the business can't afford both. So that needs to be addressed by the ACCC. Maybe in version 2.0 of the guidelines, the ACCC will address that issue. And one thing I'll just show in finally is that the Pattinson case said deterrence is what it's all about, but there's a very, very strong, it's not really a dissent, but he just seems to totally disagree with the majority. Edelman in Pattinson says, is this right? Is it really all about deterrence, or really is it about just desserts? Is it about punishment? And I think the jury's probably determined this issue quite strongly in favour of deterrence, but there is a a view that maybe it isn't all about deterrence. There are other factors which really should be taken into consideration, or a different approach should be taken. So that's all I had. Hopefully that's helpful, leads you through the document. I commend both the guidelines to you and also Michael Corrigan's article. And if you have any questions about this, feel free to give me a call or send me an email. Bye-bye.